for tuning into Mirror Now. You're watching the weekend edition of the Urban Debate with me, Aarti Subramaniam. A war of words has erupted between former Home Minister PC Chidambaram and current Law Minister Kiren Rijiju over sedition. This comes after Chidambaram questioned the Law Minister's statement in Parliament that said that there was no proposal to scrap or reconsider the sedition laws. Kiren Rijiju has hit back, saying that several cases were also lodged under the UPA regime. Now, this political controversy once again has revived the debate about sedition or colonial law and whether or not it is needed in modern India. To discuss that, joining us this evening, Advocate of the Supreme Court, Desh, Ratan, Nigam, and Sanket Yenagi, KPCC, that's Congress spokesperson, joins us this evening. Gentlemen, good evening. Thank you so much for speaking to Mirror Now. Mr. Nigam, let me start off with you. Kiren Rijiju has said that there is no specific order that has, from the Supreme Court, that has said that seditions should be scrapped. But isn't that a rather narrow look at the issue, given the fact that, sedition has repeatedly come under criticism from the Supreme Court, albeit it's been oral criticism and not written in a specific judgment. And B, we're living in 2021. This is a colonial law and we need to question its relevance, especially given that that law was aimed specifically at the freedom movement back then.
Aarti, one must know the constitutional position as of now. In 1962, it was Keharnath Singh's case versus the state of Bihar, where the 5 judges constitutional bench upheld it to be constitutionally valid, section 124A, which deals with sedition. And time and again, it has been held to be constitutionally valid, and it has found its takers in Supreme Court, and they have said that the law is needed. There may have been oral observations here and there, but they do not become part of the court record or the official record anyway. And sometimes the court also observes in their judgment something which may not be linked with the case. It is known as obiter dicta. So we don't pay much attention to those statements within the judgment itself. However, this law which has been there, it has been there with the Congress time. Congress saw through it. It was the UPA governments which implemented it. Even the present government is implementing it and using it. Whether it was misused in the past, yes, it was misused in the past. Whether it is being misused in the present, yes, like with every other law, it is misused, like whether it is a dowry, anti-dowry laws or the domestic violence law that has been made. Their aims and objects are very good. They are there to deal with specific situations. However, the chances of misuse of law, every law exists. Whether one likes it or not, it is where the courts come into picture. Otherwise, we do not even need the courts. If the fundamental rights were not, disturbed, or some legal rights were not, disturbed, or some disputes were not there. So we live in a society where everybody is a human being. The possibility of human errors are there. And the courts have very clearly, in some of the cases, clearly said, from 1962 onwards, after Keharnath Singh's judgment, that the law has to be sparingly used. There's no doubt about it. And especially in case, it has to be used especially in cases where there is incitement to violence, attempt to violence, or there is an intention to incite violence of the government of the day. It does not say state, it says use the government, lawfully elected government under section 124A. So the law is needed. Yes, the law is needed because we see that kind of incitement against the governments, whether it is Bengal, whether it is Bihar, UP, Jammu and Kashmir, Kerala, take any state. So the fact remains that it has to be there on the statute book. It is there, and the courts have held it to be constitutionally valid. No court in its order has called it a colonial law as of now. It was used for a different purpose prior to independence, but after the independence, its purpose has become different. It is used in different situations. There is no colonial power to rule you, whether it was Congress or whether it was any other party. It is meant for the people who are criminals who want to disturb the law and order, peace and tranquility of this country. And therefore the law exists and it has stood the test of time. But the fact remains, is misuse, if at all it is there, has to be checked.
Mr. Nigam, let me actually pick your legal brain a bit. You've mentioned several Supreme Court orders that the court has upheld the constitutional validity of sedition. but it has also very crucially drawn a difference, and you mentioned that very briefly about incitement to violence. Even in, I think, and please correct me if I'm wrong, in the Balwant Singh case, the Supreme Court said that merely shouting slogans is not seditious and there has to be an incitement to violence. Now you've also said that this has been misused by both governments, and how do you plug this loophole? Isn't there enough provision otherwise in the laws except sedition, which is slapped repeatedly against dissenters? Now, about 326 cases have been registered between 2014 and 19. But it's not just the number. Let's not look at the number in isolation. It's the specific cases in which the law has been used against those who've raised questions against the government.
The individual cases have to be gone into specifically. One cannot make a general statement. Each individual case stands on its own footing. So one cannot make a generalization. If it is misused, there are courts to check it. Yes, police has to be careful, and irrespective of any political party, it should not be misused. However, if the law was not misused, again, I would say courts were not needed in this country. So whenever the mistakes are made, the courts are there as checks and balances. And the law, especially the challenging times that the country is seeing nowadays, even during the Congress time, these challenging times were there. So they had also used, the governments of the day had used this law. And the misuse was also there at that point of time. Whether it was malified or bona fide or unintentional, that is another question. We can debate on that aspect some other day. But the fact remains, the challenging times require such law to be there on the statute book. If it was unconstitutional, Supreme Court bench would have held it unconstitutional. However, the 5-judge constitutional bench in 1962, and it has been upheld till now, that it is constitutionally valid. And they have laid down certain conditions where it can be used, not mere words, as you said in Balwant Singh case, but something more is to be there. If it leads to violence, yes, sedition law will be applied. However, mere words will not, but they have to attendant circumstances. Other evidences and circumstances will have to be seen, that whether those words have the potential to lead to violence or they actually led to violence. And please remember, an attempt to create violence is also punishable under Indian law, under the IPC. So not only that violence should have taken place, even if you do one particular act towards achieving your objective, towards committing a crime, that constitutes attempt, and that is also punishable as if you have made that particular offense.
Okay, let me go across to the Congress for their view. Mr. Yenagi, was sedition a good law up to 2014, and after 2014 has suddenly become a bad law? We've heard Mr. Chidambaram, we've heard Kapil Sibal several times in the past raising questions over the need for sedition, but during the UPA regime it was slapped several times, and suddenly after 2014 is when the law has become bad.
You see, the data, it clearly shows that in the year 2016 around 35 cases were registered under the sedition law. And in 2019, around 93 cases have been registered under the sedition law. So there has been around 165% of increase. And out of these, 93 cases, charge sheets were filed in only 17% of the cases. The conviction rate was, the conviction rate has been only 3.3%, as low as 3.3%. So in this sense, that all is demonstrating that many times the cases have been filed unnecessarily or without any evidence, or there is a lack of evidence, or for some vengeance the cases have been filed, or to prevent someone to hesitate or to protest, sometimes the cases have been filed. So in all the way, it is trying to point out that there has been a misuse of this sedition law. Insofar as the constitutionality of the provision, more particularly section 124A of the IPC is concerned, which deals with the sedition law, the point is very clear that it has been constitutionally upheld by the Supreme Court in 1962. But the way it has been used subsequently, more particularly within a period from 2016 to 2019, where there is a considerable increase in the percentage and there is a less percentage or the lower percentage of the conviction, then there is a clear-cut instance of misuse of the sedition law, and for which reason, time and again, the Supreme Court has cautioned that sedition law cannot be used as a tool to curb the protest or to curb anything which is in the form of a protest, in the form of as if it is violation of the sedition, violation of certain rights or privileges of the government. Sedition is only in a case where someone wages a war or someone wages something or by any other means which would indicate that he is waging a war against the government. That is not the case here. If someone is protesting against the right or someone is protesting against the policy of the government, it cannot be termed as something which is amounting to sedition. And most of the recent incidents which have been recorded for the sedition and wherein the sedition law has been invoked by the government is clearly an instance to curb some protests or to curb some in one way or the other, the protest against the policy of the government. And that is how the conviction rate has been very minimal. And in that case, 97%, around 97% has been the acquittal. So the Supreme Court has time and again reminded that there should not be a misuse of the sedition law, and we are not in the colonial period, and it requires a reconsideration. Yes, Aarti.
Can I respond?
Mr. Yenagi, then do you oppose the law per se, or do you oppose its misuse? Because you're hedging your bets here a little. You're talking about the numbers that were there during the NDA regime, but there is also several cases that have been slapped under the UPA regime. So, like I said, the law can't suddenly become bad. So, are you in complete support of the scrapping of the sedition law, or are you just opposed to its misuse?
So, as such, sedition law is a must and it is necessary. But the way it is being used, or the way it is being slapped unnecessarily, is something which is worrying everyone and even the judiciary. So for which reason the misuse of the sedition law is a question, is a point of debate, not the constitutionality of the sedition law, which has already been upheld by the Supreme Court.
Can I come in?
Okay,
Yes,
well, your view is a little different from what Kapil Sibal and Chidambaram has. I just want to point out, Mr. Yenagi, your view is very, very different from what the former Law Minister and Home Minister of India have to say. Mr. Nigam, you wanted to come in. Please go ahead.
Let me correct Sanket that waging a war is not covered under this section. There are other sections to deal with it, like treason, the ones deals. So therefore, waging a war is not an issue under 124A. So it is against the government if you incite violence or you intend to incite violence or disturb public tranquility and public peace and order. It is for that purpose it is there. And to deal with waging of war, there are different other sections to deal with it. Hence, that distinction is to be maintained. So far as conviction rate is concerned, that requires, police and judicial reforms. That's a very different topic as to why these conviction rates are low. Courts have clearly said the shoddy investigation which is there, the abdication of duties and responsibilities by the policemen, the lack of competence of the policemen and abilities of the policemen to do those complicated, investigations which require scientific temper, tools, and knowledge. So all those issues are there, and that's a larger debate. And that is why not only in this particular sedition case, but various other cases, whether it is a crime against women or rape cases or grievous injuries against women, other serious crimes, the conviction rate is not very high because of the reasons I have said, and that is why I've said that the investigation should be independent of the law and order branch of the police. And that is the reform, and in some places it has been done. But the fact remains, therefore, the law is good. As like with any other law, chances of misuse are always there because it is the human element which implements it. And we have to have those reforms, as I've told you in brief, that those reforms are a necessity so that these loopholes can be plugged so far as it's misused, investigation, and finally conviction is concerned.
Mr. Nigam, just very quickly though, a law doesn't necessarily have to be relooked or examined by the Supreme Court for the executive and parliament to decide that perhaps it is not the best law and we need to reconsider it. Why wait for the Supreme Court? Why put the ball entirely in the Supreme Court's court instead of actually having a dispassionate view of sedition as a law?
Aarti, let me tell you, Parliament is people's body. It reflects the will of the people. The day people of this country want that this law should go, it will go. TV debates or channels cannot, dictate it to the parliament.
And how is that, Mr. Nigam? Because no, but Mr. Nigam, I'm sorry. Let me play devil's advocate here. You said the day people want the law to go, it will go. We don't have referendums on specific laws. So how do we say that people are opposed to this law? Because if you go on the street and ask somebody, they said, and you ask them, well, is dissent being curbed and are people being arrested under sedition or UAPA just because they've challenged the government? They'll probably say yes. So how do you establish or how do you ascertain that it is people's will which matters when it comes to laws like sedition?
Let me answer that. When the political parties will see that there is a swell for removing this particular law, I am sure they are going to put it in their manifesto and try to take it before the parliament, before the people during elections. None of the political parties have said so in their manifesto, so far as I remember. Maybe one or two small parties may have done so, but none of the mainstream parties have done so because they know the pulse of the people. And some people on the streets maybe here and there may be saying so, but the fact is the day people of this country through their elected representatives will want, it will be reflected in the manifestos of the political parties and it will come into the parliament. And we in the TV debates may have our view and some channels may have a view. But the fact remains, the will of the people is reflected through their elected representatives when the issues are taken to them or the issues are generated by people, and then they decide through their elected representatives whom to elect and whom not to elect. This is how democracy functions. We don't go for a referendum on each and every issue. So that's very clear. As of now, I don't see any demand or movement, maybe from one or two people here and there, but there is no movement as such to remove them.
Well, Mr. Nigam, on a lighter note, pardon my cynicism, but I don't think any political party in India will want to scrap a law that they've both been using several times. Mr. Yenagi, you had a point to make. Please go ahead.
Yes. As such, the disagreement about the government policy or disaffection about the government policy or the working of the government or the administrative action of the government cannot be termed as something which can be brought under the sedition law. At the most, it can be said that a protest, assuming for a moment in governmental action or a policy, is the subject matter of debate, or it's a subject matter of protest, or it's a subject matter of any of the protest in a way which may sometimes lead to violence. But however, it cannot be termed as something which is against the interest of the state. And everyone has got a right to protest. In the recent times, any person who is involved in the protest has been charged unnecessarily under the sedition law. And that has to be demarcated specifically, and that has to be distinguished. And sedition law cannot be imposed on such person or such incidents, and which in other way is taking the right to protest. So right to protest is something different, which has to be protected and honored by the state government. In other way, the state government, which has a bounden duty, is taking the side of taking the shelter under the sedition law, which is unfortunate. So for which reason, in my personal opinion, that sedition law must prevail, but in a different form. And the misuse of the sedition law has to be dealt with by the appropriate, in an appropriate manner by the court of law. And the government has to be very cautious. It has to reframe the law so that it should not be misused. Yes, Aarti.
Well, Mr. Yenagi, I appreciate your point. Like I said, you're taking a very cautious approach to sedition compared to some of your party colleagues, but that is your view and I respect that. Mr. Nigam and Mr. Yenagi, thank you so much for speaking to Mirror Now on this issue. Sedition laws, should we be scrapped or not, back in the focus once again.